Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com. Hi everyone. Thank you for tuning in to another episode of the Immigration Lawyers Podcast. This is episode number 49, spanning July 10th to July 16, 2017, a recap of the events in immigration law and in my practice. As usual, it's been an incredible week with a bunch of activities coming in for the administration and its effect on people. The immigration field is the hot button and hot topic issue. Everywhere I go, people are talking about it. When they find out I'm an immigration lawyer, they want to talk to me about it. It's constantly in the news. The material is endless and it touches on various different parts of society, whether it's family-based or it's business-based. It's people who are victims of violent crimes, asylees, refugees, businesses, investments, everything. It touches on every family exists. So it's amazing that this is going on. Now, one thing about putting videos out and podcasts about this, I see another dirty side of it that, living in Los Angeles, I usually don't see, which is that there is a lot of vitriolic hatred towards the immigrant community and as a consequence, immigration lawyers as well. And I see that when some people's responses to these videos, but for the most part, it's all been positive. There's a weird thing that happened this week. There was a news story about an Asian woman who, pretty much American, came as a child, was going to Big Bear to go skiing or just have fun, and she booked an Airbnb room, and once the person that was the owner of the home found out she was Asian, she canceled the trip and said, I'm not going to take orders from Asian, that's why we have Trump, crazy things to say, and didn't let her in. So, in Southern California, you wouldn't even expect to hear that kind of rhetoric, but it exists. So it's a very sad thing to see, but this kind of stuff exists all around us. When we're looking at how the administration is dealing with this, is kind of fanning the flames. The RAISE Act, which is something, a bill by two senators that was introduced, which calls for really cutting in half the number of lawful immigrants coming to the U.S. by getting rid of the diversity visa program, cutting family immigration by cutting out parent-based immigration, sibling-based immigration, cutting the kind of children that could be U.S. Lawful permanent residents through their parents. All these things are moving ahead and behind the scenes are being talked about with the administration. And the travel ban is an extension of all that. Luckily, a district court in Hawaii, I think it's the same judge that undid it last time, broadened the span of the people who are considered relatives of potential non-immigrants who are coming to the United States or immigrants to include grandparents. Now, the administration is probably going to fight this. This was a State Department decision to define who is a relative and who isn't for the purposes of the travel ban. And just because of the way the executive works, they may have the right to limit and do things as they want. We'll see how this works out in a couple months, especially when it goes back to the Supreme Court and it gets further analyzed. But it's an interesting thing that happens. But beyond the travel ban, especially for those who have clients from the Middle East, they know the administrative processing delays for non-immigrant visas and immigrant visas is continuing. I have two cases still. Now they're in the 14th month of delay. I contacted the embassy multiple times. They're probably frustrated as how many times I'm emailing them and seeing my name constantly saying what's going on and them saying can't do anything. To be honest, I prefer not to email them because I already know what they're going to say, but my clients will keep calling me and emailing me asking me to do it, and for every 4 requests I'll send at once because I know it's not going to help their case. I think it hurts them to keep, after all this time, keep pushing them on it because they can't do anything in it, or even if they could, apparently they don't want to. If they waited this long, what difference does it make for them? We've had congressional representatives, senators contact the embassies to ask what's going on. Nothing has happened. At this point, I think maybe a lawsuit would be the way to go, but a lawsuit is both costly and a scary thing for a client to take on. So I don't know how that's going to happen or what's going to happen with that. Hopefully maybe get together with a couple of attorneys that have the similar issues and pool our resources and to do these kind of writ of mandamus lawsuits to get these cases moving forward. Now, along with the administration's attack on immigration, the DHS is looking into TPS, temporary protective status, to check whether the people who are getting TPS don't have criminal records and don't have aren't a financial burden. Now the reality is these are checked anyways when people do get TPS. So it's another one of those things that the administration is saying they're going to do, but for the most part, it's already being done on a regular basis. But it's very scary if you're on TPS. You think you're out of the danger in the U.S. And now things can be reviewed. They also said they're going to potentially start reviewing F1 student visas, the ones that are here in the U.S., every year, forcing them to reapply for permission to stay in the U.S. so the government gets a chance to look at the system and see what's going on with these cases. This is a heavy burden on the students. One is the cost of it. The second is the fear of being denied. And just as we all know, there's incorrect denial sometimes. There has to be appeals. They're going to try to do it on their own. They might not fill out the paperwork right. It's just a heavy burden to put on people who are coming here spending a ton of money to go to school and continue education and could really be used as a resource for the U.S., but they're looked at still as a liability, if you will. And interesting that happened was a memo that was produced from the Senate. So what happened is a senator was troubled by the privacy issues entailed when U.S. citizens in particular are at the border entering the U.S. and the searches that could happen, the constitutional aspect of some of these searches. So they contacted CBP. The acting head of CBP responded, and the question was about, can you search U.S. citizen phones and stuff? What is the legal standing of doing something like this? I did a separate video for 5 minutes, and I really break down the memo. But an interesting thought that came out of it is this. CBP said that they could check what's in the phone because it's kind of like luggage, opening up a bag and see what's in there. So if you have data stored on your phone, your laptop, that's for them able to be searched. However, if you have something on the cloud, whether it's foreign or domestic, they can't access the cloud because I guess theoretically it's not located right there. So that would be something a warrant is required. They probably wouldn't check. And also, if a U.S. citizen wants to enter the U.S. and not be checked, they can still demand not to be. The government could potentially hold on to those devices because of security reasons, but they can't really go in and check them. So they can't hold on to U.S. citizens. The takeaway for immigration lawyers I got from this is, and this is a very small risk immigration lawyers have their stuff searched, or lawyers in general. And so I'm not saying everyone do this. It might be going overboard. But if you are traveling internationally and you have to deal with CBP and you have confidential information for clients, especially immigration lawyers where we do have immigration-related confidential information for potentially people that would be searched by CBP for immigration violations, maybe don't have that in your phone or your laptop. Store it all on the cloud and only keep files within the laptop that you're not afraid of being searched. So if you do handle a lot of these cases, especially if you do a lot of removal cases, for me, most of my cases, it won't be effective even if they search them. But if you're doing removal stuff that could have consequences for the information, don't store it on the electronic device. Keep it on the cloud. And so if you are searched forcibly, they can't theoretically search the cloud. Well, we'll see how that practically plays out. But that's the answer that CBP gave in that memo. Now, CBP is finally instituting its exit biometric programs. They started to in Chicago and in 5 different cities. So when you're leaving the country, whether you're a U.S. citizen, foreigner, whoever, they're going to scan you, biometrics, take a picture. So the police state is real, and it's coming at you. They're tracking us everywhere. It's been in the plans to do this for over a decade, but they're finally getting the funding, apparently, to do it. Going back to the travel ban, interesting that happened is with all the hubbub and news about the various teams of young women that are coming to the U.S. to compete in this robotics, the young women's robotics competition, I believe it was. It might be just young people robotics, but the 2 teams that were denied coming to the U.S. from Ghana and Afghanistan had applied for visas, not allowed to come in. The news made a big deal about it, and the Trump administration personally went and undid this and issued the visas for the students. So that's something to keep in mind. If we are able to get news attention to cases that are worthy, where people, worthy is a subjective term, but it'll capture the public imagination and provide understanding, these things can be pushed back. So in the court of public opinion plays a really big, important part of this. In the positive side, to help undo a lot of this damage, but on the negative side, as you know, whenever one immigrant does something potentially wrong, even if they didn't do it and they're claimed to have done it, the whole community takes a hit. So we got to be very cautious and really let people know about the positive stories that are out there. I always let people know about generally, without breaking privacy, about the type of clients I have when I'm talking about it, what kind of people they are, what kind of contribution they bring to the U.S., what kind of sacrifices they have to entail to come here, how they adapt and bring the American spirit alive with their presence here. So that's something, the story is very important that we tell. Finally, with regards to new stuff, this one isn't directly related to what we do, but it was interesting. There's in the news now that President Trump allegedly his son had contacted a Russian attorney to get some dirt on Hillary Clinton during the presidential race. Now that attorney, that woman is in the news. We talked about all that stuff. Apparently, Attorney General Lynch during Obama administration had given her parole to come in the U.S. to testify. So that was interesting because the AG gave parole. Now, always when I'm reading the INA, they say, Attorney General can give parole. Usually, Attorney General, I don't see that on a daily basis in what we do. If anything, DHS gives that kind of stuff. But here, Attorney General Lynch did give parole for this person to enter the U.S. to testify. So it's a little bit immigration-related thing that popped up in the news. Now, I've been listening to the AILA recordings from the New Orleans trip, and it's very interesting stuff. I always recommend if you can't make it, or even if you do make it to the conference, buy the recordings and listen to them in your free time. It's just good to go over all this. Chances are you probably know a lot of the information, but one little nugget of knowledge can really be a game changer for your practice. One thing that was interesting, very interesting to me, is one of the speakers was talking about marriage cases and the marriage interview process. That attorney was from Boston, and she said that in Boston, 100% of marriage-based immigration cases undergo a Stokes interview. That means they separate them, interviewing separately, and compare their answers. That's amazing. I've never seen a Stokes interview. I've never been through a Stokes interview in California. And frankly, I wouldn't take a case as suspicious. But going from rarely happening, at least for me in LA, and the various field offices in California, to seeing Boston do 100% is first terrible, terrifying, and really scandalous. That shouldn't be necessary. But it's important to know if I do a marriage case where I start the case here, then the client decide to move to Boston, or they hire me from Boston. Before this, a lot of times I would say, listen, your case is so clean, you guys, if it's really the case, and the clients are very well spoken and not nervous, and they can go handle it on their own, I would say, yeah, go ahead. But if they're putting under Stokes interview, no matter what, that's something that needs representation every time, because that level of investigation alone, being one-to-one with the government, is something that could potentially lead to problems. So if you are a Boston practitioner, let me know if that's the case, because that seems pretty extreme for people to have to undergo Stokes interviews every time. And if you're not, I hope that information helps out that you have a Boston case. That's something you're going to have to deal with. And one other thing she said was during these interviews, they asked that the applicant and the petitioner provide their keys. So first of all, they want to see that they both have keys to the same house. That's an indicator they're living together. I've never had to deal with that before. Also, they'll take the keys and they'll compare them in the light to see whether the jagged part of the metal is the same and all that. It seems extreme, but they got to do what they got to do. So be mindful. Tell them to bring their keys and make sure their keys match. One aspect of it is I always tell my clients not to bring their cell phones to the interview. They could go off their interview and cause a distraction. It could be information on there or a picture of that. There could be a problem. There's just no good that could come out of it. So I say leave your cell phone within the car and don't bring it with you. Now, a memo that came out, I think it was from Chicago. It was one of those liaison minutes that one of the chapters did. I can't remember which one it was. But the director of that district said that the officers can't forcibly look in your phone. They could ask you a question and you could show them, for example, joint pictures that you print out so they can see it, and joint documents, but they won't forcibly ask for your phone and review it. I wouldn't even risk it because it's one thing for the regulations to say one thing, but who knows what the officer will do at the actual interview. Safe thing for me to say is just don't bring your phone. It's a distraction that you don't need. Finally, this is just something small and not that complicated, but I used to always two-hole punch the top of my paperwork that I sent to the government, but a couple years ago I stopped. Now I just do a paperclip. I don't staple things because apparently when a file goes to the service center, when you're doing a benefits-based petition, they have to undo all the staples, all this kind of stuff, and feed it into the scanner. So by adding staples, it adds work to them. I just put one of these binder clips, depending on, I have different sizes of these things. If you have video, you can see it. Obviously, these are the binder clips. You all know what that is. So if the file is bigger, I put a bigger one, smaller, and I just send it like that so you can view it. But I stopped putting two-hole punches in it. I don't know why, but someone was saying in one of the recordings that they always two-hole punch the top. And then I remember I went to a naturalization interview last week, and the officer was two-hole punching all the paper I gave him. I'm like, well, I should just relieve him of that. It's going to be a little bit 0.01% helping the officer get their stuff done faster, not have to be annoyed, have to do a two-hole punch something. That's that much more help to your client's benefit for them to be able to get the relief that they're looking for. So that's another practice pointer that came up. Now with cases, I had 2 consultations this week that had some interesting questions that came up. One is with regards to proxy marriages. So proxy marriages in different countries allow, some don't, is when 2 of the parties aren't at the same location when they're getting married. So the typical marriage civil ceremony where you go and you say I do in front of each other and sign together. There are countries in the world that permit one party not to be there, have someone stand in their place when that's happening, and that's okay. Now, I had this happen, frankly, my cousin's in Germany. He married his wife through proxy marriage, was able to get her German green card without a problem like that. So when that happened, I always thought it was okay, but the U.S. doesn't accept that. The State Department won't accept that. So if, for example, you are an Iranian person in the U.S. Or American, whoever it is, and the foreign spouse is in Iran, and you have a proxy marriage, the State Department won't accept that for an immigrant visa. You have to go and meet afterwards and consummate the relationship. So it gets kind of X-rated, but you got to consummate it, keep records that you got a flight together, maybe at a hotel room, and that way they know after the marriage you met and consummated, and that's when it becomes a valid marriage. And so that's something that pops up, and people, when they do their own green card cases, aren't aware of this. They get that denial at the embassy, then it's havoc. They have to restart the process, and it's no good. Now, with regards to non-immigrant visas, an interesting happened, and this happened for a case a while ago. So I have a guy that came in. He was on a student visa, applied for his wife, or his wife applied for an F2 visa, and that was a proxy wedding. And she went to the embassy. She went to one embassy for an interview, was denied because it was a proxy marriage, wasn't appropriate, denied the F2, out. And so they came to me and I said, well, this is a proxy marriage. You can't do that. The Foreign Affairs Manual states that in these kind of situations, what the embassy is supposed to do is give a tourist visa, a B2 tourist visa for the foreign spouse to enter the U.S. Once they enter the U.S., they're consummated, and then they request change of status from a B2 to an F2. However, in this particular case, they eventually went to another embassy quickly afterward and told them about the situation, my advice. And the embassy said, you know what, it's just a hassle for you to have to go do change of status. We're just going to issue the F2 dependent visa for you right now. Just go have fun. Client was really excited, but I wasn't. Why? Because later on they're going to say, oh, you committed a visa violation. You weren't actually married when you were issued this visa. And that could be a problem because they might not trust or believe them, and they say, well, the embassy did this, I don't know any better. They might say, oh no, you lied to the embassy, said the marriage was consummated, that's why they gave the F2. They might not have kept records in the system. They probably didn't, to say the one person came open and honest at it requesting this kind of visa. Now, in the DS-160, they did request the B2, so they could say request the B2, the embassy did it. So it's maybe fixable with an explanation, but the fact that you have to go and add an explanation is just a hassle on its own if they accept it or not. So the correct way to do it is to get that B2 and do change of status. It probably applies the same for L's and H's. Wherever a proxy marriage happens, they have to get the tourist visa to come in, consummate, and then file change of status. The second was this. A guy came to my office, married multiple times, wanted to file for his natural daughter before she turns 21 to get her green card, was a citizen himself. They all lived abroad, didn't want to come to the U.S., but I said, listen, just get it out of the way. He said, by the way, I have another stepdaughter that's from an older wife. She's like 28 now. Can I do anything for her? I said, well, I looked at the I-130. It said a step-parent could file for a stepchild as long as the parents were married, the step-parent and the natural parent were married before 18. So I said, okay, that's fine, let's do it. So once I got into it, I was studying it a little more. I went on forums and stuff, and people said, actually, if the step-parents and the natural parent divorced, then you can no longer file for the stepchild. And I was like, oh no, I get bad consultation advice. So I did more research, looked in the adjudicator's field manual, and they have a line that says, typically if a divorce happens, they can't petition. However, there are exceptions if the relationship between the step-parent and the stepchild remains. Unfortunately, they don't give additional information on that, of how that works. There are a couple of court cases they cited, which weren't the best, and I have to further read it and go into it. But it was something I wanted to see if you had dealt with. What kind of information did you use to prove that the step-parent, step-child relationship continued after the divorce? Sometimes it'll be easier because maybe the stepchild continued to live with the step-parent. They had custody of them in their house, and they're sending them monthly checks for payments for life and all that kind of stuff. That shows a continued relationship. Having pictures every year, visiting each other for Thanksgiving or whatever, that kind of stuff. that might be the way to do it. But what happens when, the child was older and went to college and they live together, but they have a good relationship? Does that work or not? It seems like one of those things that's on the line. I'm not sure about. So it'll be interesting to see what y'all have and what your opinion is. As usual, it's always been an interesting week. It's kind of slowed down with clients, thankfully, this week because I was kind of overwhelmed with stuff that I backed up. Really pacing yourself is so important. When it comes to business planning, and I'm just really switching minds right now, I was listening to a conference speech by a guy named Gary Vaynerchuk. If you haven't listened to Gary Vaynerchuk, also known as Gary V, he's a prolific internet marketer. If you on Facebook follow him, you'll see his videos every day. He does a lot of these kind of activities that I do times 100 or maybe 1,000, and he's really on top. He's the number one in the game. And a person at this conference who was coming out talked about what they had was a nursing company. So they provide high-end nurses that go and take care of sick people, sick parents, and that kind of stuff. And they're doing very successful high-end kind of service like that in Singapore and Hong Kong and all these wealthy territories. And they were moving into the China territory, and they were hitting a wall. Now, a lot of Chinese people have family members, they'll do it, or it's just too pricey for them to necessarily get a home care person from this company. And he asked, well, how do we penetrate the market? And Gary Vee said something interesting. He said, why don't you just become cheaper? And, it hit the mindset where the guy had was, have this high-end quality stuff. But Gary Vee said, listen, if you want to get that market, you got to adjust to what that market needs and maybe put the prices lower, develop a different system that allows it to cost cut and all that. And it hit me because my perspective has always been, keep the quality high, and with my low volume to be able to do that, might have to charge more and more every time. At first I was worried about charging too much, but one thing I've seen when talking about the immigration lawyers is actually I charge pretty much the average price in LA at least. So that wasn't too bad. But when I get more and more clients calling me and I just can't handle it and I have to quote some prices sometimes that when I'm really busy that are much more than I would ever want to do, but just because I'm so slammed, I can't take on the case. It feels bad because a person doesn't like that. They want to work with me at the same time I'm letting a client go. So I was like, well, what can you do to keep the regular price range but still get these clients? And adjusting to what they need and adjusting my firm to what they need. It's something I've been talking about a lot, especially when it comes to ways of taking less of my time so I can provide the same service but less time during the menial stuff like filling out the forms. One thing I tried and it took so much time was with a website and it's Zoom. That didn't work out. I'm going to be trying Prima Facie next Wednesday. This Wednesday I'm talking with them actually about that and just testing the system to save a little bit of time to keep my prices in the normal range, and you potentially hire a staff member or maybe a relative or something like that that can handle some of the busy work so I can just focus on the service that I'm providing. So that's a wall that I hit because I don't want to grow the firm when it comes to numbers of people or size. I like it keeping it cozy like this. It hit a wall, and I know a lot of people have multiple paralegals and stuff and have offices for them. I just don't want to do it like that. If you have a practice like mine, you've been doing it for, my own practice I've had for 3.5 years. If you're doing it for longer and like this, I'd really like to talk with you and see how have you dealt with this issue if you like to keep it small. Or if you finally made the decision to hire staff, how you made that decision. It seems like it's a really easy decision. Most people I know do have a paralegal or two and they hire it's not an issue. To me, it seems like a really big deal to have to bring people on board and have that on payroll and the responsibility that comes with that. So I'd be really interested to see how you dealt with this issue. My email is info@jqqlaw.com. You can always contact me directly. We'd love to hear from you. Thanks again for everyone who's following, liking on LinkedIn and on YouTube and Facebook. It is a real pleasure getting to know all of you. That's about it for today, episode 49 from July 10th to July 16th, a weekly recap. Hopefully I have more material coming up on a bi-weekly basis, if bi-weekly means twice a week. But for now, the weekly is all I could do, and I'm trying to stuff them in and getting them out the latest by Monday, even though my goal was Sunday. But thanks again for listening. I'm John Khosravi. Until next week, have a great one.